Good evening, everybody. Very happy to welcome you to this year's Percy Sky Lecture. About 20 years ago in Toronto, I attended a meeting of a bunch of medical curators, and we ended up at a factory of Janssen Inc., where they had a collection of contraceptives, and it was amazing, kind of funny, I thought at the time. I had no clue that we would one day become home to that collection. But what happened was that Percy, who's in the foreground here, is joining us this evening. Percy was the CEO of a company that manufactured IUDs, had been the first company to advertise publicly for sale the pill in 1961 in Toronto, when it was still technically against the law. And over the years, he had built up the largest collection of historic contraceptives in North America. Percy was at a juncture where he was going to retire. The company was moving different directions in its product line, so he felt he needed to find a new home for that collection. And he established enough protocol with the company to go look in the United States, and he ended up looking at 3 places. We were one of those 3, and happily we were the recipient of that collection in 2004. We opened the Sky Gallery upstairs in 2009. I encourage you to come back later in the week or on the weekend when we're open 10 to 2 to see that collection. The most amazing thing he's done since then, however, is to be a generous donor who did not micromanage what we would do with the collection. So we have curated and interpreted the collection in light of the American experience. The other thing he did that I think was wonderful is he has endowed this lecture series. About 4 years ago, he gave us a gift of $100,000 so that we each year can offer this lecture, have speakers on some aspect of the history or policy as it relates to contraception. So I want to thank Percy for his generosity. And at this point, I'm going to turn it over to Brandy to provide the rest of the introduction of our speaker.
Good evening. I'm so glad you could be with us today, and I'm excited to present Jessie Hill, who is Associate Dean for Academic Affairs and Judge Ben C. Green Professor of Law here at Case Western. She started here in 2003. But before that, she also worked in First Amendment and civil rights law here in Cleveland, and she's also worked for the Reproductive Freedom Project of the National ACLU in New York. So she has a wonderful breadth of experience, and she brings wonderful insight to this topic as to many topics. I'm really excited for you to join us to hear her talk about controversial coverage, faith and the fight to ensure contraception. I'd like you to please warmly welcome Dr. Jessie Hill.
Thank you. Thank you for that wonderful introduction. I have to say it's really gratifying to see so many people here tonight to come here and talk about insurance. It's not every day. I also want to begin by thanking Jim Edmondson and Brandy Scalace and, of course, Percy Sky for his generous support of this lecture series. I've had the opportunity, being here at Case, to attend some of the Sky lectures, and they've been wonderful, and I'm really honored to be this year's Sky lecturer. So what I'm going to be talking about then is the sort of the history of the fight for contraceptive coverage or contraceptive equity. There are a couple of themes that I'm going to kind of try to intertwine throughout this talk that I think have been present throughout the history of the fight for insurance coverage and access to contraception. One of them is just that the fight for contraceptive access has been intertwined with almost every other major social and political issue of the second half of the 20th century. So gender equality, of course, but also racial equality, class, religious freedom, abortion rights, and gay rights all kind of figure into this picture. And then the second theme that I'd like to sort of bring out in this story is that one of the basic points of disagreement in this conflict, in particular between religious rights and rights to access contraception, one of the basic themes has been a disagreement over whether contraception is basic health care or not, or whether it is something different, whether it is some sort of personal, moral, and ideological choice. And I think both of those themes will kind of play themselves out as I take you through sort of the narrative of the history of this, this debate. But first, I want to start with 5 things that maybe you didn't know about the conflict between religious rights and contraceptive equity that I'll be touching on over the course of this lecture. First, it's not as new as you might think. We've heard a lot about religious freedom claims and the claim to deny insurance coverage for contraception by groups organizations such as Hobby Lobby. But actually, this fight goes back at least to the 1990s, if not earlier. It's not mostly about the US Constitution. I'm a constitutional lawyer and constitutional scholar, but most of the issues really center around statutory law, not constitutional law, so I'll talk a little bit about that. It's not always just about contraception. Sometimes it's about abortion, too. Here's one that, as you might have heard from the Hobby Lobby case from a couple of years ago, that corporations are persons that exercise religion. Really, as I'm going to talk about a little bit, that's not a completely new concept. They've been considered persons for some purposes since at least the 19th century, but now we have a new variety of corporate person that is actually a zombie. I'll mention that a little bit later, too. And finally, the history of contraceptive equity is intertwined with the history of, among other things, gay rights in America. I'm going to briefly mention some statistics. I know these kinds of slides can be a little overwhelming, and maybe you know some of these things, but 99% of women of childbearing age who are sexually active use at least, or have used at least one contraceptive method. That number includes natural methods like natural family planning, although those methods account for a relatively small percentage of that number. Approximately 66 women of reproductive age are using a contraceptive method at any time, and the proportion of women using what's called LARC, long-acting reversible contraception like IUDs, has grown from about 2% to 12% over a period of 10 years. So on the topic of religion, approximately 2/3 or to 3/4 of Catholics, mainline Protestants, and evangelicals who could become pregnant actually use one of these methods that are considered highly effective but religiously controversial, such as sterilization, hormonal contraception, or the IUD. A couple of other figures nationally, about 45% of pregnancies are unintended. That's a statistic from 2011. And in Ohio, the number's about 55%. And about 40% of unintended pregnancies, when you take out miscarriages, about 40% of those remaining pregnancies end in abortion. Finally, just to give you a sense of the cost of contraception, it can range from the most expensive, which are IUDs, intrauterine devices, that can cost over $1,000 up front, out of pocket, without insurance coverage, if you didn't have insurance coverage, whereas the pill tends to range between about $15 to $50 a month, again, without subsidy. Okay, so to begin, this history, of course, begins in the 1960s. You've probably heard of the case Griswold v. Connecticut from 1965, in which the Supreme Court established the right to use contraception, although that right was limited to married couples in the Griswold case. Now, that case was actually preceded, I just want to mention briefly, by 2 cases, Poe v. Ullman and Trubeck v. Ullman, which were also cases out of Connecticut. Connecticut outlawed, criminalized use of contraception and at the time, and although it was also kind of widely known that middle class and upper class women could access contraception through prescriptions from their private doctors. But clinics like Planned Parenthood were more at risk because they were very visible. And those were the places where lower income women had to go generally to get contraception. So this was a law that sort of from the outset discriminated in a lot of respects, including with respect to class. Interestingly, also, those 2 cases before Griswold were dismissed by the court, the Supreme Court, because the Supreme Court said Connecticut hadn't been enforcing any sort of criminal law against contraception and wasn't going to do so in the future. That's why Estelle Griswold, who was the director of Planned Parenthood in Connecticut at the time, went ahead and violated the law so that she'd get arrested so that she could bring a test case up to the Supreme Court. But Poe involved a couple in which the woman wanted to avoid pregnancy for medical reasons because pregnancy, she had certain conditions that pregnancy would have been very threatening to her health if she were to get pregnant. And so she was seeking contraception for that reason and claiming she couldn't get it because it was illegal. Trubeck, on the other hand, again, a case brought at the same time, involved a woman who didn't have any medical issues. She just wanted contraception for family planning purposes and was very upfront about that and said, I want to be a lawyer, I'm going to law school. She did end up going to law school, and I believe she still teaches at Yale Law School, actually, and wanted contraception for that reason. So I raise this because I think it's interesting to notice that from the very beginning of this sort of legal saga, we have this notion that sometimes contraception is quote unquote therapeutic, and sometimes it's just for family planning. And there's this sort of separation between the two kinds or uses of contraception. Okay, moving quickly through the next one, Eisenstadt v. Baird, 1972, extended the right to use contraception to non-married couples, to single individuals. And then I mentioned also, because I'm telling here the story of religious rights as well, a case from 1972 called Wisconsin v. Yoder, which is kind of in a lot of ways considered the high watermark of religious rights in the United States, where the Supreme Court upheld the right of Amish parents to exempt their children from going to school after age 14, even though state law required them to go until 16. The court said if religious exercise is substantially burdened by a law, the government has to show a, quote, compelling interest that it's trying to serve with the law, and that the law is necessary to meet that interest. And that was a decision under the First Amendment, free exercise of religion clause of the Constitution. Okay, then 73, we have Roe v. Wade, established the right to abortion, and then almost immediately in 1973, we have the so-called federal church amendments. Church was the name of the sponsor, not religious church, which are still in effect, that say basically individuals can't be forced to perform abortion or sterilization or discriminated against because they perform or refuse to perform those procedures. So conscience protections, religious protections were kind of, again, baked in almost immediately into this story about reproductive rights in America. Okay, we're going to skip ahead a little bit to the 1990s then. There was a bit of a shift. In what's considered another landmark case, Employment Division v. Smith in 1990, the Supreme Court reversed course from that Yoder case about the Amish parents and said, actually, we don't think the First Amendment provides a right to exemption from generally applicable laws. So you actually have no constitutional claim to an exemption if there's a law that applies to everyone and it just happens to burden your religious beliefs. This case created quite an uproar in Congress, and people on both sides of the political aisle were upset about it. And in 1993, Congress passed unanimously, it passed unanimously in the House with a voice vote, and 97-3 was the vote in the Senate for the Religious Freedom Restoration Act in 1993, so-called RFRA. And that's a federal law that states that any government action that imposes a substantial burden on a person's religious exercise must be the least restrictive means towards serving a compelling government interest. Otherwise, that person gets an exemption from the law. So if that language looks familiar, it should, because it was exactly what the court decided was the rule in the prior case, Wisconsin v. Yoder, with the Amish parents. So the Congress was trying to return to that earlier rule that gave religious persons a right to exemptions from generally applicable laws. And I just want to say that this law could only have passed at that particular time in our history. I want to set the stage a little bit for that, because and certainly, maybe it only could have passed with so much support. That's what I'll say. So much bipartisan support at that point in history. And this is an important law because this is the law that's at issue with respect to the Hobby Lobby case, the Affordable Care Act's contraceptive mandate, and so on. And the reason I say this, that it could only have passed at this time with so much support, is that this was an era, 1993, when the civil rights movement of the 1950s, 60s, and so on was kind of comfortably in the past. And really, we didn't have people using religion as an excuse to discriminate anymore. We didn't have segregation academies. We didn't have Bob Jones University sort of standing up and saying, we have a right based on our religious beliefs to discriminate on the basis of race. That just wasn't cool anymore. Nobody was doing it. It was socially unacceptable. But at the same time, the gay rights movement had not quite picked up yet. It was, of course, had been around for decades, right? But it hadn't picked up the kind of political steam in the US that it did later on. There wasn't widespread political public support for same-sex marriage. The polls were running against that. And of course, we didn't have Obamacare then either, right? So nobody was thinking that this law could be used, to discriminate. Just, great, we're going to carve a huge hole out of every generally applicable federal law for people who have religious beliefs that are violated by that law. What could possibly go wrong, right? Nobody was thinking that it could be used as a license to discriminate. In 1997, the Supreme Court, in a sort of complicated decision I won't go into, decided that RFRA could only be applied to the federal government, that it was only constitutional as applied to the federal government and not the states. And then Congress actually did try to repass another version that would be more widely applicable. And it failed. And it failed in large part because the civil rights and civil liberties groups all peeled off. They had all supported RFRA initially, and then they all pulled back their support because at that point, which was late 90s, around 2000, they were starting to be confronted with cases that were coming up through the courts out in California of landlords who wanted exemptions from the fair housing laws because they didn't want to rent to unmarried couples. So all of a sudden people realized, whoa, this is a really big carve out from equality laws that could potentially be dangerous. Okay, and then finally, 1998, around the same era, there was a very influential law review article by Sylvia Law, who's a professor at NYU Law School, who made the case very carefully that the failure to cover contraception in employer-provided health insurance is illegal sex discrimination under the federal anti-discrimination law, Title VII. And she gathered numerous facts and statistics and so on to support the sort of sex discriminatory aspect of this, pointing out one of the facts at the time was to point out that women spent 68% more than men in out-of-pocket healthcare costs, largely because of the failure to cover contraception. 2000, the EEOC, actually, advocates really took note of this argument and started to push it. And in 2000, the EEOC, the Equal Employment Opportunity Commission, decided exactly that in the case that was brought in front of it, that the failure to cover all approved forms of contraception in employer-provided health plans when other preventive drugs are covered violates Title VII. And then there was a legal success. And I was actually, I was saying earlier, I was at the ACLU Reproductive Freedom Project during this time when these cases were starting to come down. And Erickson v. Bartell Drug Company was the first federal case, court case, in which a court also made the same ruling. At the same time, in the mid-1990s, it became popular for states to start adopting contraceptive equity laws requiring insurance coverage for contraception. But again, there was always this thorny issue of religious exemptions. And in some of the states that were a little more progressive on this issue, they turned to women's rights groups and said, what do we do about this exemption, this religious exemption? And the organization said, well, look, we get it. people have sincere religious objections. But we also want to make sure that employers aren't using this as a way of imposing their religious beliefs on other people, on their employees. So we think to make sure you are really only covering those employers, protecting those employers who are going to have sincere religious beliefs that are burdened by contraceptive equity requirements, the requirement to cover contraception, and that they are not likely to have employees who think much differently. We think you should make sure that only employers who have a religious purpose, who primarily employ people of the same religion, who primarily serve people of the same religion, and who are basically a church or very closely affiliated with a church, should get this exemption. And that's what some of the states like New York and California adopted as so all employers had to cover contraception except for this narrow class. At the federal level, there were also multiple attempts to get a federal contraceptive equity law passed. It was going to be called EPIC, the Equity in Prescription Insurance and Contraceptive Coverage Act, and it continually foundered. It was introduced multiple times, but no one could agree on what the scope of the religious exemption should be. So despite some bipartisan support, it never made it. It was an epic failure, if you will. Okay. So in the early 2000s then, Catholic Charities, which is a Catholic nonprofit social services organization, social welfare organization, litigates over the narrow scope of the exemption in California and New York, which required Catholic Charities to provide contraception for their employees, many of whom were not Catholic, right? Catholic Charities lost. The state said you have no First Amendment right here. Then 2010, fast forward, the Affordable Care Act passes. It requires coverage of essential health benefits. But what does that mean with respect to women's reproductive health care? That was left unspecified, undecided. And was that an oversight or a mistake? No, of course it was absolutely not a mistake or an oversight. It was a very savvy political move to get the law passed without too much controversy. Let the Department of Health and Human Services decide what are essential health benefits. The ultimate decision is that means to cover essential health benefits that all FDA-approved contraceptive drugs and devices have to be covered by any insurance plan without cost sharing, without copay or deductible. The religious exemption that the Obama administration comes up with initially is identical to the one that Catholic Charities was fighting against, identical to that narrow exception that the women's rights groups had proposed. However, that didn't go over so well, as you might have heard, and there was political uproar, and in 2013, the Obama administration decided to extend this exemption, make it a little broader, and said basically any nonprofit employer who holds itself out as a religious organization and opposes providing contraception coverage for some or any of the services, or all of them, gets an exemption. And the government would step in and make sure that those women would continue to get coverage. However, Hobby Lobby and some other companies who were for-profit and therefore would not qualify nonetheless brought suit because they wanted an accommodation as well. And that led to the case of Burwell v. Hobby Lobby. In Hobby Lobby, the owners of the store, which was a closely held corporation employing over 13,000 people, objected to providing insurance coverage for 4 forms of contraception because they thought it had a post-fertilization effect that those 4 forms did. And to them, pregnancy begins with fertilization. That's not the generally medically accepted definition of when pregnancy begins, but their religious beliefs told them, you know, it's a person, it's a human life from the moment that sperm fertilizes that egg, and therefore they would be complicit in an abortion if someone took one of these drugs with their coverage and it happened to have a post-fertilization effect, which actually, it's not even clear that any of them ever really do. It's just a possibility. But in any case, they claimed that RFRA should protect them against this federal law the Affordable Care Act, right? Because this RFRA protection gives you more protection against federal laws than against state laws. The Supreme Court decided in this case that Hobby Lobby is in fact a person who exercises religion, and that contraceptive coverage mandate, the mandate under the Affordable Care Act, imposed a substantial burden on Hobby Lobby's religious exercise. And I want to just say, and this is a little bit of a digression, but because corporations have been found since the 19th century to have all kinds of constitutional rights that they can sue to protect. So it's not so much that, to me, troubling that corporations can be found to be persons, but it is troubling to think about religious exercise of corporations. It's unclear also how recent and how meaningful the corporation's religious commitment really has to be and how it shows that commitment. And Hobby Lobby has really opened this can of worms with respect particularly to Catholic hospitals, religious hospitals and Catholic hospitals that often undergo mergers, changes of ownership, get bought and sold, but retain their Catholic identity throughout, even though no one affiliated with it with the management is necessarily Catholic, or the employees are not necessarily Catholic, but the Catholic Church at some point wrote in requirements that they can't perform or provide certain forms of reproductive health care, and that identity continues through sort of generations of sale and merger and so on. And so we also now have this problem of sort of zombie, that's where the zombies come in, these zombie religious corporations walking around sort of exercising religion that really is not part of their original identity. Okay, so, and then also in Hobby Lobby, the court said, okay, we'll assume, for the sake of argument, that it's an important, compelling interest to provide comprehensive insurance coverage for reproductive health care. We're not gonna totally stand behind that decision. We're just gonna assume it. But we're still gonna strike the law down because it's not the least restrictive means requiring employers to provide insurance coverage is not the least restrictive means of meeting that goal. Instead, look, the government can just extend this accommodation that it gives to nonprofits, it can extend it to for-profit organizations, or it can create a whole new government program and pay for it itself. We don't see what the problem is. And then meanwhile, as far as we know, Hobby Lobby's female employees are still not getting access to these drugs and devices, but also religious employers continue to litigate the nonprofit exemption, and some of them brought a new generation of lawsuits. Zubik v. Burwell is the recent one that made its way up to the Supreme Court, where they say we can't even opt out. Even opting out of providing contraception violates our religious convictions. Because once we opt out, now we know that the government is going to provide it. So if we opt out, we're triggering the process by which women get contraception, and now we're complicit in this sin. That case went up to the Supreme Court, and the Supreme Court kind of said, we think the government and the employers should try to work this out a little more than they have, and they sent it back to the lower courts without deciding anything. So looking forward, we don't really know very much. We have a very sketchy plan. What's going to happen in this state of affairs? My guess, though, is that they're going to get worse, not better. Currently, the proposal for repealing and replacing the Affordable Care Act does not contain an explicit change to the contraceptive coverage mandate. However, it could be modified by administrative regulation, which is how it was passed in the first place. So it doesn't need a change to the law that Congress is going to pass. It's also likely to have a very severe impact, something that hasn't really been touched in all of this story, because it was all done directly through private nonprofits or the government, is poor women's access to contraception. The new proposal it proposes to defund Planned Parenthood and also provide severe cuts to Medicaid, which has been a major source of contraceptive coverage for poorer women. And then also kind of in the wake of all of the controversy as it stands now, have to remember that there are still 28 states with contraceptive coverage laws, and that those laws may be more relevant than ever before. So, as I said, I just want to bring back a few themes to think about as I close here. The battle over contraceptive coverage, over contraceptive coverage, but over religious exemptions more generally, about the extent of individuals and organizations' right to exempt themselves from general laws that may burden their religious beliefs, has played out in various other contexts besides this one. It's playing out currently in the context of sexual orientation and identity. We've seen this movie before with respect to race. It happens again and again and again. We haven't really resolved it. Also, just this notion of whether contraception is essential healthcare is kind of the central fight here, the central thing to get that advocates have been struggling to get recognition of. The EEOC first in 2000, and then the Affordable Care Act defined contraception as essential healthcare. And really the Affordable Care Act, I think, was the first clearest statement of that notion that we've had in American law. But this kind of idea that it's not therapeutic, that therapeutic means something else, it means dealing with other kinds of conditions, that it's really, I've seen the phrase controversial clinical practice, is still out there. And it's still very much alive in some circles, and it's very much driving the idea that maybe people can be exempt from providing it, right? I mean, it's much harder to say, sure, you can, because of your religious beliefs, deprive people of essential health care. If everyone was on board with that concept, it would be a lot harder to be sympathetic to religious claims. And finally, I just want to raise the possibility that women's equality both reinforces the notion that contraception is health care, because, if you recognize that women should maybe have a fate other than, or if you think women's only sort of natural fate is to be pregnant and or parenting, right, then you're not going to see contraception as healthcare. But if you see, if you don't see the world that way, then you can more easily accept that contraception is healthcare. But at the same time, the identification of contraception and contraceptive equity with the women's rights movement, I think, has helped us to see it, has also caused us to see it more as a political or ideological choice. So it's a little bit of a circular problem where women's rights advocates push for contraceptive coverage and contraceptive equity, and then it starts to make contraception into a political matter, whereas really you need to accept women's equality in order to see it for what it is, which is basic fundamental health care. So I will stop there, and I think we're going to have a conversation next, but thank you very much for your time. So nice to sit here.
So that we don't blind ourselves, we're going to mute that. And then let's pull these forward into the light a little bit. I'm going to sit on that side of you. You're going to sit on that side, that's right. So what we want to do now is to have kind of an impromptu interview to talk through some of these other issues that she's brought up now that we have the context with Jessie, and then we're going to open up to questions with the entire group so that we can really delve into these issues a little bit further. So Jessie, thank you so much. That was great. Wow, where to start? One almost wants to start with world's greatest health care plan of 2017. The English teacher in me is sad. So, but what I really want to start with, I think, is, you said that this is really not new, and that these battles go back a long ways, and that they have real implications, or that they're part of this context of race and equality, and also of gay rights. And we didn't really delve much into that. Could you say a bit more about how these access points and religious freedom and these law cases have to do with that?
Wow. So, I mean, I think that one thing is, in a way, even the subject of insurance coverage for contraception is it's a middle and upper class woman's concern, right? Most women weren't affected by this whole fight through the 90s and forward because they got they didn't have employer-provided health insurance, right? They didn't have insurance from that source. They were going to Medicaid. They were going to Planned Parenthood clinics that could provide free or very low-cost contraception. I think a lot of the conversation now, there's conversation around making contraception available over the counter, which is really a problem if you can't pay out of pocket for it. So, but it goes back. There's always been this kind of dichotomy where really middle and upper class women can find their ways to get access. The sort of birth of Planned Parenthood, if you will, and the movement to legalize contraception and also abortion was precisely because these sort of clinics that provided services predominantly to poor women were so visible. They were visible targets, right, that the prosecutor could go after. And that's why the Griswold case was so important, because it was really the case that was going to ask the question whether poor women were going to have access or not.
Well, and I know that in terms of insurance and access, one of the points that's been brought up recently concerning transgender rights and similar kinds of exemptions that are happening with people using religious freedom as a means of sort of getting around provisions. Do you think that this is going, I mean, you said actually earlier already, do you think this is going to get worse? Are we going to see more and more uses of religious freedom rules to kind of carve out spaces?
I think every time there is a rights claim and an expansion of rights claims, there's sort of a counter reaction, right? And often it takes the form now of a conflicting rights claim, because we've all discovered that rights are really powerful, and federal courts are really powerful too. And so, yeah, I think that's also been a product of the fact that the Obama administration has expanded its interpretations of certain sex discrimination provisions to include transgender and to include sexual identity, sexual orientation. And almost immediately there was this issue presenting itself, for example, with religious universities. Did they have to respect these norms as well? And so they started making claims under Title IX, and now we have exemptions under Title IX. So I do think it's a pattern that is, it's played itself out very prominently in the contraception context, but it really is a story that's about all sort of civil rights and equality rights.
Could we go back a little bit to, you were talking about that they carved this huge hole because it wasn't, I love this, it wasn't cool anymore to discriminate. What a world, right? Could you say a bit more about what's changed? I mean, it was only like 7 years apart, the two rulings. Could you say a bit more about what other factors were leading into this, either legally or contextually or socially?
Yeah, I mean, I think that it really was, a big part of it was that not just, I mean, I think it was a large part that people just had not made religious claims of a right to discriminate. And as soon as RFRA was passed in 1993, people started talking about how it could be used to exempt religious individuals. And also, like I said, with the gay rights movement, although it had been out there for a long time, there hadn't been a lot of legal victories until, out in again, more sort of left-leaning states or municipalities, cities in California started to adopt protections that extended to not just on the basis of race and religion and gender, but also sexual orientation. And so as soon as there was a protection, all of a sudden there was this conflicting rights claim that reared its head. And that was really, I know that the groups that like the ACLU all jumped off the train at that kind of moment when they started to realize that this is a huge way of undermining all the protections that everybody is fighting for. It opens up this possibility always of just sort of writing your own license to discriminate based on religious beliefs.
And we talked a little bit about the Affordable Care Act and the fact that it finally says contraception this is essential health care. This is something that you should have access to. And yet, we're watching it potentially being repealed right now, and there's fights, and we're not really sure how safe it is. In your opinion, what matters more to the provision of contraception? State laws, federal laws?
Yeah. I mean, it would be hard to overstate the importance, I think, of the Affordable Care Act really in expanding contraceptive access. So it's been so important. I mean, again, putting aside the fact that, you know, a lot of women never got their health care through private insurance, but for those women who do, every study you look at shows that paying for it makes women use it so much more, right? I mean, shockingly, it turns out if you don't have to scrounge some money together every month, that you're going to be able to use contraception more regularly, which makes it more effective. And also the sort of longer acting methods like intrauterine devices that have a huge upfront cost. Even if they are tremendously cost effective, if you can't shell out $1,000 is really a conservative estimate, you're not going to be able to afford that device, even if it makes financial sense. So I really think for now, that has been a huge element. And it's been a big part of the story about why abortion rates have fallen too, because more women have access to those long-acting, very reliable methods. But I think moving forward, we're going to have to start thinking about action at the state level again, because I don't think things keep going in this direction, we're not even going to have basic health care through the federal government.
And insurance access, I think it's so interesting that I agree with you in your claims that who would think discrimination was good? And yet we clearly see that it's utilized again and again by the image of zombie Hobby Lobby is going to make me really happy for a long time. But
I didn't come up with that term, by the way, but
well done, though. But the issue of access to health insurance seems so critical, because I think the point that you're making is not only is contraception crucial, and we have this wonderful collection upstairs, the Sky collection, which shows how valuable contraception was for a variety of reasons, in lowering venereal disease rates, for barrier methods, in helping women control family size so that they could actually feed their children, that helping women take careers, and again, promoting equity in other ways.
Right.
It just seems to me as though, it's almost as though one of the arguments you're making is that in people suggesting that if they opt out, they're complicit, they're almost trying to control beyond what that they're capable of doing. And can you say anything more about that and a couple of your final points?
Yeah, thanks. That's a really great question. So I think you're right. I think that that was sort of where things are going, right? So at first, we just want a right to not violate our own religious beliefs with respect to ourselves, and and maybe our employees who are often of the same religious persuasion. And that was what that really narrow carve out was initially about. And then there was a sense, no, it has to be a little broader than that, because there are these complicity claims, and so if even if your employees don't share the same religion, why should you have to violate your principles? And then after the Hobby Lobby case, which again, to remind you, involved a corporation that employs 13,000 people, and then after that case was over, the next generation of cases is, no, we can't even opt out. It's clear that it's just the attempt is to stretch further and further beyond the sort of borders of what goes on inside the company, and that really they wouldn't even stop, it seems like, until the mandate goes away altogether, right? Because almost anything is going to make them complicit in the provision of contraception. So I think that's a really important point. And then the other, I guess, to bring back the other theme that I heard you saying with your question is, I think what I've been trying to do partly with this presentation is to put the debate over contraceptive coverage in the context of this larger debate around exemptions from anti-discrimination laws. And we don't necessarily think of contraceptive coverage laws as anti-discrimination laws, and actually in Hobby Lobby, Justice Ginsburg wrote this great dissent where she said, well, what about, what's the next thing? Do we have to exempt people from discrimination laws and, what about race discrimination? What about fair, Equal Pay Act and things like that? And, the court's response is, well, this is not a non-discrimination law. And I kept thinking, but of course it is. Of course it's an anti-discrimination law. That's exactly what a contraceptive coverage provision is meant to do.
Yeah. And historically, I mean, it's not as though discrimination wasn't part of contraception access and even just the Comstock Acts. I mean, we were talking about, you were constantly working against a group of people. It could be women, but frequently it was poor women. And one of the interesting points in the gallery upstairs is that one of the most affected groups of people were young female factory workers who had no choice but to work in order to provide for their families. But if they got pregnant, they not only had another mouth to feed, but lost wages because they had to leave their jobs. And so there's this whole, many people who are of lower income even today really can't afford to be away from work for as long as it might take, might not be able to afford family care, or child care. So it's a much more, it's a complicated issue that, as you say, is not new, and it goes back into history in a lot of different ways. So thank you so much. I would really like to open this up. I know that there's so many points that we can ask about and questions that we can ask Jessie to clarify. So we've got 2 microphones here, and we encourage you to come down. You can line up, you can ask questions, and Jessie can help answer those questions. I know, don't all everybody wants. I think you are clicking yourself. Okay, right here.
Faith and contraception, and yet essentially it was really presented in the concept of religion and contraception. Is that because of the legal definition of religion and faith, or how do you extend that kind of to the values of family,
Values.
which are connected to essentially access to contraception?
I
Promoting contraception.
might need to repeat that. So I think the question there was the title is Faith in the Fight to Ensure Contraception, and a lot of the terminology in the legal cases refers to religion instead of faith, and are those 2 things
Right,
connected?
and I also heard kind of the idea that faith can work in the other direction too, or that there can be conscience-based or faith-based reasons for wanting to provide contraception. Is that what you were getting at too? Yeah, it's a very interesting point, and it's something a lot of scholars have started to focus on recently, is, how asymmetrical our conscience protections are in the law. So throughout the law, there's this view that faith, in some religion, conscience, I'm using these terms interchangeably right now, this notion that it has to be protected against provision of certain services, and that the conscience claim only runs in that one direction. But really, and as I've worked in this field, I've heard lots of providers come to me and say, I provide reproductive health care for conscientious reasons. And the law has very few protections that run in that direction. Actually, when some of the religious protections, and I think it was when RFRA was adopted, there was a concern that physicians would use it as a reason to protect providing abortions. They wanted to make very sure that it was clear in the legislative history that it could not be understood to create that kind of religious right, that instead it was protecting the right to refuse. So part of it is just the way the law is structured around seeing conscience protections in one direction, although I do think there's a bit of a movement afoot to change the discourse around what role faith plays in that. Absolutely. Thank you. Hi.
So somewhere I heard one time that your right to your religion sort of stops at the end of your nose. I don't remember where I heard that. But in terms of RFRA, I was thinking, at what point does your right to object to something become a harm to someone else?
Right.
So it's fine if you have maybe it's fine if you have a small organization and everybody believes the same thing that you do, but when it encompasses 13,000 other people, where does the court say okay, this is too much, and now it's your religious belief or your belief in faith or whatever is becoming a harm to other people?
Right. I think after Hobby Lobby, it's not clear where that line is. And part of the problem is the Supreme Court's decision to accept these complicity claims. And once you open that complicity can of worms, there's just no end to it, because and the other problem is that the court tends to be, and that courts tend to be very deferential when people say, my religion requires X, my religion requires Y. No one wants to push on that too hard. No one wants to say, well, does it really? Let me see like the catechism or something. No one's going to say that. The courts are not going to say that. That's uncomfortable. It's getting too close to the issue. So, to areas where they don't have competence. So, and then once you start making these complicity claims, you can claim virtually anything, right, is going to make you complicit in wrongdoing. So it gives enormous ability to control other people's conduct that you don't want to be associated with somehow. So,
and wouldn't it also, in a way, almost make it, could you discriminate against employing that person at all? Could you fire them for using contraception because you're somehow being complicit by making sure that they have a job that allows them to pay for it? I mean, it's not clear where that might
absolutely.
end.
Absolutely.
Hi, I think that was a great lecture, and I wanted to say that I totally agree that the right for contraception is totally a discrimination issue because, men have an easily accessible barrier protection that's over the counter, that's very inexpensive, but women can't control that part.
Yeah.
And it's been clear that women asking a partner to use a condom is not always something that they'll comply with, and a woman has no ability to impact that. So having access to, other options that can be woman controlled is really important. And my question here, that was just a comment, I just wanted to say, as a physician, the question of whether or not physicians can exempt themselves from learning the ability to perform contraceptive measures, I think is a very important one, especially if you choose voluntarily to go into a specialty that requires the knowledge or ability. And my understanding currently is that there's no legal precedence yet on what physicians can have to be trained in or can opt out of being trained in. And I was just wondering if you knew if there's anything out there currently on, whether physicians who are, say, OBGYNs, who for religious reasons feel like they should not perform abortions, which is fine because they don't have to choose to perform them, but do they have to be trained in them at least, because currently under the auspices of their profession, that's considered, something that they have to do. I was wondering if you knew anything about that.
So my understanding is that no, and that the conscience protections that I mentioned in federal law would actually protect them from having to even do that in the context of training. I do know that there has been a requirement that residency programs have to at least, it's not a legal requirement, I think it's the sort of AMA or the accrediting body that requires residency programs to provide that training that people can then opt out of, but they have to make it available. And even that was widely flouted for a very long period of time. I think that there was recently more of a movement to force residency programs to really live up to that and to show that they were making abortion training accessible, but yeah, I don't. There's no legal mandate at all that I'm aware of. I do want to say something else about the other gender equity aspect, which is something I didn't talk about. It's sort of, again, it's sort of the older history of the contraception movement. But when these cases were working their way up through the courts in Connecticut was a big hotspot for the contraceptive access litigation leading up to Griswold. Connecticut had this law that was just brutal in that it didn't allow women who even needed to avoid pregnancy, as I kind of alluded to, for very serious medical reasons, who would die if they became pregnant. These women brought suit and said, I'm going to die if I become pregnant. And the Connecticut court said, sorry, the law says you can't have access. And meanwhile, there were access to condoms that, again, were illegal, but they had these huge exceptions for, avoiding venereal disease, what was called venereal disease, right? And that men could access contraception widely with very little legal barrier to them. So again, it was another gender inequity that was sort of built in from the very beginning.
Upstairs, we do talk briefly about the Comstock Acts as part of the collection in the Sky Gallery, and it's when contraception is made illegally in the United States. And I happened to do some research in London on the Contagious Disease Acts, which are not exactly the same, but the Contagious Disease Acts were to stop venereal disease, and they targeted only single women, so prostitutes, but also factory working girls and all these kind of things. And so we're, again, it's like we're going to stop contagious disease by only looking at this one tiny slice of the population who, it's not like they were walking by men and they got the venereal disease. It's not like they pointed at them and gave it to them. Yeah. So it is really interesting just how this happens on both sides of the, both in Europe, in parts of Europe and also in the United States. Are there any other questions that we can answer for, okay, we've got one coming here.
In the state of Colorado, they provided better support for birth control, and they found that abortion rates decreased. And I'm wondering if there are other stories like that or other means to, it seems like the people who are opposed to abortion are also opposed to birth control, and there seems to be, aren't there success stories, other success stories like Colorado's that would convince that same group of people to actually at least support birth control?
Yeah, thanks. You would think so. And again, that's the other story I think I kind of alluded to, is that the abortion rates have been plummeting over recent years. And, it's such a complicated question, what actually is the cause. But a lot of people think that at least a very significant cause is access to long-acting reversible contraception that, because it's so reliable, you just have, your IUD inserted, you never think about it again, and you're protected. And that this has been, a huge innovation of Obamacare. And, that's what is really galling to me about the Hobby Lobby case, is that case was not about contraception, it was about abortion, and their opposition to abortion. And they didn't want women to have access to IUDs because maybe, and again, it's an open scientific question, maybe in some cases they prevent pregnancy by stopping a fertilized egg from implanting, as opposed to stopping the egg from getting fertilized. And that, in that infinitesimally small unknown number of cases where that happens, where the woman has to get pregnant and be using that particular IUD, and it has to happen on that occasion. We don't even know if it happens, right? And here they are worried about these hypothetical abortions when they're facilitating real abortions by denying IUDs, which undoubtedly women can't afford, right? Most of them, most Hobby Lobby employees, right, without coverage. Yeah, I can't hear it.
I would like to ask about the legal underpinnings of Congress being able to withdraw funding from Planned Parenthood for performing abortions when that's a legal procedure in this country. And if we're basing it on beliefs, then what prevents other people who do not believe in war and violence from defunding the military?
Right.
Because that wasn't on, I just want to repeat it. I'm not going to do it nearly the justice that she did, though. Her point was, help me out here. It was
What is, does Congress have a legal right or a legal basis for denying funding to Planned Parenthood based on their performance of abortions, which is perfectly legal? On that logic, shouldn't we be able to deny funding to the military if we're opposed to killing? To killing,
yeah. I'm down with that argument.
Yeah, I mean, there is, right, I agree. I mean, I think that there's leeway for the government to use its money to, however it sees fit, to fund this and not fund that. On the other hand, where states have tried to do that, have tried to pull funding from Planned Parenthood because they provide abortions, they've been sued again and again. And in most cases, the states have lost. So there is a rule that you cannot punish someone for their exercise of their constitutional rights, if that's the reason you're doing it. And to me, it seems pretty transparent. So I expect if they do pull funding entirely, that they will be sued over it, I think.
I have a question about the faith aspect of it. Can you hear?
Yeah, now I can't.
Okay, about the faith aspect of it. The question of the sincerity of the faith, has it ever been ruled on? The courts generally tend to punt on that and assume sincerity. But I'm wondering, what if some group like, say, the Satanic Temple, which has been quite successful in challenging court laws about monuments and so on, would there be a line drawn about, or questions about how sincere one must be for one's faith exemption to be upheld?
Well, yeah, I mean, I often give that's a great question. It's a great point. I mean, I often give the analogy of with Hobby Lobby, if this were a prisoner claiming that, I think the analogy would be, a prisoner who doesn't eat pork for religious reasons saying, there's pork in this food, and the prison says, no, that's a hamburger. Well, I think it's got pork. I think it's pork. No, it's beef. Well, no, I feel that, it may have touched pork at some point down the line, therefore I need a different meal, right? I mean, yeah, I think that actually if it were a different kind of party, courts do tend to look a little closer at claims by some individuals more than others. So, but, those kinds of lawsuits have been tried, and sometimes they have been successful. So, but you're right, that courts tend to, it's a really difficult problem. They don't want to look too closely at the sincerity of someone's religious beliefs. Although, I feel like here it's not so much a question of Hobby Lobby's sincerity as whether we can carry this complicity argument out to the 19th step, which they do in that case.
Hi there. You talked about the Connecticut case and with women having life-threatening illnesses if they were to become pregnant. So I'm a rheumatologist, so I prescribe teratogenic medications all the time to my patients. Is there any precedent in terms of providing those patients with some kind of contraception? Brought up.
So it's interesting. One of the things, again, that I didn't talk about too much, but in all of these state laws, now there are some state laws that make a distinction between therapeutic uses of contraception, and again, this distinction between therapeutic and non-therapeutic uses of contraception. But there are some, while we still have several states that just protect contraceptive access, there are other states that say, create these wide exemptions for religious employers, but then say unless the contraception is being prescribed for a reason other than family planning. And it's a little unclear does that have to be the only reason? Does that have to be just one of the reasons? There's a lot of wiggle room in there, but that is something that is still, so even in some states that have these contraceptive equity laws, even where employers, opt out for religious reasons, they may have to cover those kinds of uses.
And who decides that?
Well, I think the insurer decides, yeah.
That feels really safe.
Yeah, right. I mean, a lot of this kind of, a lot of that gray area happens in the shadows, right, of the insurance company halls, I guess.
Yeah. In the morning, like the GOP vote. Yeah.
Right.
Thank you so much for just talking and giving this presentation. I appreciate it. My question is, as a woman who, my mother was very politically active in the 60s and 70s with the Equal Rights Amendment, and then with, supporting Roe v. Wade and getting that covered. What I would like to know is, what does the legal challenge look like that will permanently decide that contraception is a basic health care? What does that look like? What could we foresee in the future? And how strongly might our countrywide or worldwide protests matter?
Yeah, that's a good question. I think, Okay. Oh, yeah. Easy to do. I think, I don't know that it goes through the courts. I mean, I guess, the biggest, in much as I tend to think of things in terms of court cases, because I'm a litigator, I think really it's been political, it's been legislation that has moved the ball lately on this. And it's the Affordable Care Act was a huge step forward on that front. State level legislation that's going to be there, even if the Affordable Care Act goes away, is a really big step forward. I mean, right now, we don't have a federal constitutional right to health care. We have a federal statute that guarantees health care, and that's passed by legislatures. So I would love to live in a world where there's a constitutional right to health care in the US, and where reproductive health care is just simply understood as a part of that, but there are a lot more steps to getting there than there are to getting to a legislative solution, I think.
Any other questions? One more here.
There we go.
Hi.
Hi.
I was, with a lot of the political climate, it seems like a lot of Republicans are looking to ban abortion, which is currently protected by Roe v. Wade. do we think that there's a possibility that there is going to be a court case in the future of that trying to be repealed, or if that's going to be put into law?
Yeah. I mean, there will surely be attempts. They're happening already all the time, I think. But right now, my sense is that the Supreme Court, even if we get a nominee who is, like Neil Gorsuch or, a clone of Justice Scalia, the late Justice Scalia, I think, we still have they would still need to replace one more justice. On the left, there's still, Justice Kennedy is still the swing vote. He's still in favor of Roe v. Wade. So I think for now, it's safe, but it's a little scary to think that not only that, but, again, even contraception to some extent is on the table these days.
Thank you so much. Your questions and this discussion has been incredibly enlightening, and we really honor your participation with us here. I hope you will come back and see the Percy Sky collection, which is upstairs on the 3rd floor of the museum. Again, we're open 6 days a week, open till 7 on Wednesdays and 10 to 2 on Saturdays. The rest of the time we're here till a little after 4:30. We really would like you to come back and explore in a more expanded way just how far we've come and what we have to lose, because one of the most important things to us is that history does matter to our president, and I think that Jessie showed us that very well. So thank you again, Jessie, and thank you all of you for being here.